I want to discuss in a little more detail the nature of a claim that can be made for lost income, either in a wrongful dismissal claim for the notice period or in a human rights claim for lost income. The basic concept of evaluating what components should be included in the claims are basically the same. So obviously, any income the employee would have earned in the notice period will be a claim, and also any other integral parts of the compensation structure will also be included. For example, if the employee receives an incentive payment, typically on an annual basis, that will also be included if it's an integral part of the compensation structure. If there are stock options are complicated, but basically the same concept follows. If the options are vested, that is, entitled to be exercised at the time of termination, then the employee will be allowed whatever additional value would have accrued during the notice period. If the options would have vested in the notice period, then also a claim can be made of that nature. So basically, whatever would come due in the notice period, and I'm using the wrongful dismissal claim, but the same thing applies to human rights, would apply. In addition, if there is a pension plan, the pension accruals will be allowed for the notice period. That is, whatever additional value, 1 year or 2 years, whatever it may be, of service would have allowed the employee to increase his pension by, can be calculated and paid. In addition, if the pension would vest in the notice period, usually vesting is 10 years and 45 years of service combined. So if those events occurred in the notice period, then there's a claim for the loss of the vested pension altogether, because there would be no pension claim if those two criteria were not met. So if these events would have happened in the notice period, that is also a claim. There's one case in which a stockbroker who had a book of business that was saleable was trying to sell his book of business before he was fired, and the court allowed him the value of the book of business that he would have received had he been given proper working notice. So it's not quite as straightforward as I initially mentioned. All these items can be included. There's another issue involving benefits. Benefits also must be continued for the notice period. But benefits are a little more complicated. Some benefits, all benefits, by the way, must be continued for the statutory notice period in Ontario, up to 8 weeks. However, some of them are convertible. Life insurance, for example, can be converted to a new plan of life insurance, usually within 30, 60, or 90 days of termination, most importantly, without a new medical. So if you have a medical issue, if you had some kind of crazy medical history that might make you uninsurable, you make sure you convert that, because it can be done without a new medical. So that's very important. Disability insurance is more complicated, because disability insurance cannot be replaced because there's no income to insure on termination of employment. So if you do become disabled in the notice period, you have a claim for the full value of disability insurance benefits, not just for the notice period, but until the disability ends. So if, for example, you suffered a heart attack in 3 months after termination and can't work until age 65, you can claim that entire value against the employer. Again, in Ontario, benefits must be continued for the statutory period. And if you suffer an illness in the statutory period, you can make a claim against the insurer for the full value of those disability benefits, again, until age 65. I'll be discussing disability benefits more particularly in separate videos because they're complicated, but beware of all these claims you can make at the present time. Now, the employer very often will try to contract out of these claims beyond the statutory period. Now, I'll discuss momentarily in a separate video what you can do to dispute those employment contracts. Thank you.